Hi there. Today we are going to be talking about a little topic that I don't think enough of us as business owners think about. We don't want to think about it because it involves dying. And with me today is Neil Beasley from CCS, and it's great to have you on, Neil. Uh,
Thank you, Kevin. Thanks for having me today.
and I suppose this whole thing. I did a little slide here just to sort of there's a bit of an intro to you, and it was sort of this sort of thought about dying on the job, and I did look at a few pictures, and this was probably the most sort of suitable, but. It's one of those things that very few people like to think about. None of us like to think about our own demise. And I think certainly as business owners, most of us almost think we're invincible. I mean, do you come across this a lot when you speak to
Well,
people?
yes, 100%, Kevin. So when I either speak to people I get introduced to through networking, or some of my introducers, they introduce me to clients, and I know they're business owners or I find out they're business owners. When I mention about what sort of business protection, what sort of business planning, what business will do you have, a lot of them look at me, and they're completely dumbfounded.
Yeah.
They don't know, and unfortunately, without the right sort of planning, that can be geared to the type of business you have, it could mean all sorts of problems whilst you're alive. So if you lose your marbles, what's going to happen to your business there? And when you die, if you haven't got the right paperwork in place and the T's crossed and the I's dotted, it could mean tax implications for your family when you're long gone. So yes, there's a whole load of risks that come to involved, that obviously when you lose mental capacity, and then when you're long gone. So
Yeah.
yeah.
Yeah, and I think if we look at this, the key things that we need to think about, that if you did, any of us, if we just sort of drop dead tomorrow, those key things that would be impacted. Obviously, there's the day-to-day running of the business, so if you're not there, you know, how does the business run itself? What other things would you sort of say would almost sort of come into being that people need to be aware of, and
So
start
yes,
thinking about?
there's probably a number of different categories. I think the first one, many of the people listening to and watching this recording today would have heard of lasting powers of attorney. If you haven't, this is where basically you have people in place to make decisions on your behalf when you no longer can. So this is to do with your property and finance and your health and welfare, your personal effects. All right.
Because the other thing is, as you said there, it's not just if you die, but if you're in a car crash and you're on a
Yes.
life
So this
support
is
machine,
this is exactly this is
you're not
whilst you're
actually
still
dead,
alive.
so your
No,
will doesn't kick in because you're
no,
not dead, but for all intents and purposes, you're non-functioning, and so we have to
exactly.
think about both of these.
You do. So they're your personal size, but for business owners, there is a business lasting powers of attorney as well. And these are just as important, because just as you said, Kevin, you could be in an accident, you could be in a coma. If you're say a one-man band, you have a cleaning company with maybe 7 or 8 people working for you, you're the one that pays their wages. You're the one that buys the supplies, pays the suppliers. You're the one that goes out and gets new business, signs the contracts. You're the main man or woman. What happens if you can't do that anymore? Is there people in place that can access that, can sign on your behalf? Because the minute the banks get wind of people losing mental capacity, they freeze accounts, they freeze joint
Yeah,
accounts. They want to see the right documentation before the business can carry on trading. So you suppose really a business owner needs to ask himself, how long could my business run without me being there? So a business lasting powers of attorney is always the first port of call, because as you said, this is whilst you're still alive, um, and then making sure your business can survive and carry on the day to day without you there making the decisions. So that
yeah.
would be the first thing.
So let's look into that lasting powers of attorney, yeah, in a little bit more detail. I mean, these were sort of the questions I was thinking about. Is that day-to-day running of the business? There's the family implications. If you've got business partners, they you've got to be aware that if one of you goes, leaves the other one, how do you deal with that? And then the tax side of things, which we'll sort of come on to as we go. But if we look at the LPAs, you mentioned there that there were the three types.
Yes.
So to talk to us a little bit about the difference, because a lot of people won't know that it's a difference.
No, no.
I've heard about them, but if you had one, then sometimes you're not covered for other aspects. So just talk us through those.
Yes. So basically so if you imagine, let's just part the business lasting powers of attorney for the moment. Everyone really over the age of 18 should have property and finance and health and welfare. All right. They're like a pair of shoes. You wouldn't have one without the other.
Yeah.
And basically, what do they cover? Well, with the property and finance, this covers things like, if you imagine you have joint bank accounts with your partner, your own bank accounts, paying the bills, etc., etc. The minute banks get wind of someone losing capacity, so you're either in an accident, or if you're at a certain age where you might get dementia or Alzheimer's, you can't make decisions for yourself without these documentations in place. Your partner or wife or husband is on a really sticky wicket, because, as I said, the banks will freeze accounts and you can't carry on like you would do normally.
And if that had happened, then you'd have to apply to the courts and get solicitors involved.
Yes,
and
100%.
That could take what?
It's called
6 months, 12
court
months.
Protection.
Yeah.
So the court of protection, you need to apply for deputyship then, because you can't obviously get your LPAs in place because the horse is already bolted.
Yeah.
They've already lost mental capacity, so they can't sign for anything. So you need to go through the court of protection and apply for deputyship, which can take anywhere between 9 and 12 months. They're going to interview you to see if you're suitable for it. It's going to cost a lot of money, and you're going to be to and froing up into London, getting interviewed and getting grilled, basically. And then they may, 9 times out of 10, they probably will, but they may not. I mean, if you've been in debt before, if you've got outstanding loans and whatnot to various people or HMRC, they might look at you as a favourable person. So someone else would have to apply on that loved one instead. So
could it be challenged? I mean, if you've got a brother or a parent who then say, your spouse shouldn't look after I know there was the case with Britney Spears, wasn't there? And,
yes, they're not suitable. It's slightly different in the States, but no, you get 100%. If other members of the family don't agree, then you could be at stalemate then.
Yeah.
And unfortunately, whilst you're at stalemate, the local authorities are going to be making decisions on that person who's lost mental capacity, not the family. And that's really the heartbreaking thing, because obviously you're dealing with the fact that that person's not the same anymore. Because either they're in a coma, or they're not acting the same because dementia's set in and whatnot.
Yeah.
And the fact that you can't help them because you're at this stalemate with the court of protection, waiting for them to grant you deputyship. Yeah. So it's not a nice time for.
It gets really hard. So for a simple sort of investment in a document between partners, then it's just going to save you all that hassle going forward.
100%. Yeah.
And then the business one then is a separate LPA, so it's
exactly the same
for business aspects.
So it is. So you could possibly have, because you can have as many attorneys as you like. We always recommend you have 3, be it children, your wife, brothers and sisters, or whatever. With your business power of attorney, you might think that your wife and your children don't know much about the business, and you wouldn't really feel that they could make the right decisions. So it might mean you have a key colleague that works for you, that understands the business, and you could trust them to keep things going. You may have your accountant, again, because they understand the money side of things.
Yeah.
You could maybe have them. Someone such as yourself, if you're working closely with a business, you understand what's going on, you understand how the business runs. You could also be a business power of attorney. Again, it's sometimes totally different from what you'd have in your personal side of things, because, as I said already, your wife or your husband might not know, and they wouldn't be suitable.
Yeah. So what else? I think you did a little slide here for the business LPAs. So let me just pull that up.
Yes, so this is just really showing that if you haven't got the right people in place, it's a bit small, but if you haven't got the right attorneys in place, or you don't have a business power of attorney in place at all, and you're suddenly out of the picture, what would that look like? As I mentioned already, paying salaries, as simple as that. If
Yeah,
you've got a workforce, paying salaries is obviously paramount, because they themselves have got their bills to pay and everything else. And that would be the first thing to break down if obviously you've got people then not turning up for work because they're not getting paid. Um, if you use suppliers, obviously they need to be paid. Contracts need to be signed. If you haven't got someone in place to make sure that still happens, then you could be running out of your cleaning equipment or whatever quite quickly. Then if you haven't got your stuff to do your work with, then obviously it
mm,
comes to a grinding halt in that respect. If you're a company that deals a lot with signing contracts and getting new business on board and everything else, if that head honcho, if that main boss isn't there to do it, then what happens? Who's there to do it? I'll give you an example. Say, for example, if you've got two directors and they're looking to sell the business, and they've drawn up, there's a company's going to buy them out, everything's great, then suddenly one of those directors is in an accident and is in a coma, he can't sign the contract to hand the business over, sign everything over, then they're at a stalemate.
yeah,
Unfortunately, just the other director's not going to be enough. So what would happen in this aspect is that obviously the directors would have lasting powers of attorney over each other. So one can act on the other one's behalf if something happens. And then obviously we've got banks and HMRC. The minute they get wind of people losing capacity or anything, they would freeze business accounts, etc. And it just makes it very, very hard for the business to carry on trading as per usual, all because really it hasn't got this document in place.
yeah. So really, a very relatively simple. You've got to find somebody who you trust, and is going to have yours and your family's best interest, with them, and that sometimes isn't your business partner. If you put all your control to them, so you really need to think about this and talk it through with key people, and that's why having an independent person, because it's very difficult to make these decisions, with
Sometimes it's not
with
always
these people,
obvious.
because it may not be them that needs to be on that LPA. So.
No,
So, that's seemingly unfortunate. Obviously, if you're still alive, but mentally sort of incapacitated. Let's go to the sort of, I don't know, it's more serious. I mean, sometimes it's probably easier, but the death side of things. So,
yes,
if so that car crash, wiped us out completely, then we're into a completely different aspect because you actually no longer exist. You've departed, and therefore, we're looking here really at the will side of things, aren't we? That what you want to happen to your estate, and how it's worked is people will always go to the will. And I know this from my own personal situation. My grandmother wrote a will, and the whole family thought something was going to happen. And unbeknownst to us, she went somewhere else and wrote another will that was dated
all right.
later. And suddenly the whole family didn't get what they thought they were going to get. So, the first thing I would say to people when you're doing a will is tell people, tell
Yes,
where it is, yeah. And if you do change it, you don't have to tell them what's in it, but you have to say, look,
that
I've
you've
got a
changed it.
will, here it is, and it is changed.
Yeah, no,
Because
definitely.
the arguments and things that happen, post death around that are, can be awful. So, that would be
Yes.
my tip for a will is tell people you've got one, where it is, and that is the last will that I've done, so they're at least aware that one exists. But
Yes, because I think people forget that you're not going to be there to explain your will, unfortunately. So you need to make sure that everything is as up to date as it can be, and your wishes are in there
yeah,
because your executors are going to be reading as it is, black and white. So you don't leave anything sort of to chance or whatnot, because all sorts of things can happen.
yeah,
So with a when you're a business owner, obviously in this country, one of the allowances that the government give you is business relief. And if your business qualifies for business relief, that's great. So what it basically means is that however much your business is worth, it doesn't form part of your personal estate. Now, the reason why that is good is because, unfortunately, in this country, inheritance tax is paid at 40%. So you want to keep your estate within the allowances that the government give you. And as I said, one of these allowances is business relief. So it means that your business won't form part of it. So it's almost ring fenced, but obviously that needs to be shown in the will. Okay. And the way that which basically can be done is either through a business nomination clause, which will be on the first couple of pages of the will. It's just basically a paragraph that says that I have a business, blah, 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 and it qualifies for business relief. Or if it's quite a large business, it's got assets, it's got cash, and whatnot, then we can have set up a business trust, which means that that amount is ring fenced and, as I said, won't form part of your estate. And the beneficiaries of that trust, i.e., your spouse and your children afterwards, they can benefit from it, and it stays within your beneficiaries, your bloodline, your children, and whatnot. So we would always say, as a minimum, if you own a business, at least have a business clause to say that I own a business and it qualifies for business relief.
Yeah, because what people forget is, while you've got, you own a business, you generally work in your business and you get tax allowances for that. If you pass away, then don't forget, you're an employee of that business as a director. Well, that employment ceases, so you're not actually entitled to any salaries going forward. But you're also a shareholder, and those shares, if you leave those to your family, would go into their estate as an investment. So suddenly you're outside of the business relief that you're given, and they may have a set of shares that could be worth, let's say £1 million.
Oh yeah.
And then that transfer would be, if it's to your other half, there would be no tax on that, would there? But then when she died or she went to sell those, she would be taxed as if she held shares in ICI, and suddenly you're into capital gains tax and all sorts of nasty taxes that come out of the woodwork.
Yes. And your allowances that the government give you. So these allowances, I'll probably mention them again. Obviously, everybody gets £325,000. That's called the nil rate band. So you can leave that to your beneficiaries and not get taxed. When you own a house and you have children to pass that house to, you get an extra £175,000. When you're married, you get spousal exemption, so you can leave an unlimited amount to each other where the tax is paid is on second death. So if you imagine your bog standard married family with 2 children, they get 2 lots of 325 and 2 lots of 175, and the spousal exemption. That's £1 million. So it's £1 million their estate can go up to before the children would pay inheritance tax when both the parents are dead at 40%. So the last thing you want, if your business is worth £500,000, is that going into the pot with your house, your savings and investments. It's just going to boost it over that. It's almost like getting a big pot and mixing 2 different soups together. You're going to cause a mess.
Yeah.
You're going to end up losing your allowances. You're not going to want to eat the soup. You want to end up losing and obviously leave a tax mess for your children further on down the line. So even just having that nomination clause, business clause in your will is better than nothing. Obviously, if it's the last thing, you would stick a trust in there as well. But just having that nomination clause means that it's better than nothing at all.
Yeah. So and then look, we're not going to go into the personal purposes of wills and assets investment. We're very much looking at the business side. So we would leave our shares in our business into a trust that's outside our family's estate, and then it can be dealt with within there. And so to talk to a little bit about the business trust, what it can do, and there was some intricacies of maybe multiple trusts, business trusts, if the business is of a certain size.
Can be, Kevin. Yes, I mean, but what the benefits of the trust, of having a business trust, is obviously, first of all, it ring fences the business.
Yeah.
So it doesn't form part of your personal estate, and then for your beneficiaries, it won't form part of their estate either. So what I mean by that is, if you leave your business it gets sold off, whatever happens to the business, it's in trust now, and your children benefit from further on down the line. It's not going to form part of their estate. So they may be married, and further on down the line, they might end up getting divorced. Now, the main priority for the parents at that time was obviously their children. The last thing they want would to be some of their inheritance go off outside the family bloodline. So directly, the son-in-laws and daughter-in-laws can't get their hands of what's in that business trust. So that helps in that respect, and it also stops obviously generational inheritance tax. If the child is very entrepreneurial and got their own business and got a large estate, the last thing they want is a massive injection of cash from their parents, pushing them into more tax problems further on down the line when they pass on. So it's good housekeeping,
Yeah.
and just protects the business and what the business is worth, and keeps it within the beneficiaries or the bloodline of that business owner.
And look, these trusts are not newfangled. They've been around for hundreds of years.
Well, to be honest, they originate from when knights went to the Crusades, God knows how many hundreds of years ago, and people would look after their estate for them. It would be in trust. Because if you imagine going down to the Middle East, they were away for 10 years at a time fighting, then coming back. That's where trusts first started.
Yeah.
The trusts we're talking about now have been around for 20, 30 years plus. They've just been updated due to legislation, and they've been, especially the trusts that we provide, have used government legislation and obviously helped the people, the clients we're using, to help plan better for the future.
Yeah. And one of the things, because when I looked at this, was let's say you've passed, the shares in your company go into the trust, and you want to then sort of sell those shares, so you sell them back to the company, and we can talk about that in a little while. That money then sits in the trust. What the trust can do is actually lend it back to the family, so it's not given as a because once the money comes out of the trust and given in its full right, it becomes part of your estate. But you said that the trust can actually lend money back, and therefore it doesn't form part of the estate.
So if you imagine a children's benefited from their parents' estate, and they've got X amount in a trust, and they think, well, what am I going to do with it? I want to pay off my mortgage, be mortgage free. At 45 would be great. But obviously, if you say you had 200 grand left to pay on your mortgage, taking 200 grand out and sticking it into your estate, obviously boosting your estate up very quickly. So you can use a borrowing mechanism from the trust and use that money, obviously, to pay your mortgage off, but then you still owe money back to that trust. So it's almost like a little bit of creative accounting within your estate. And it just means that you're not suddenly putting a huge amount of money straight into your estate, going into that tax haven, which I mentioned already about inheritance tax further on down the line. You can use this, but there's only certain trusts use that. Sort of off-the-shelf trusts may not have that borrowing mechanism, but obviously the ones that we provide do, and a lot of ones out there do. It's just something you need to be wary of when doing planning and looking into how trusts work.
And again, trusts, there's a lot of complications. Talking through this with an independent person is vitally important, isn't it? To really look at all of these aspects and get the proper advice, not just go online, download a will that you think will work, because it invariably isn't going to cover these intricacies that you're talking about.
No, not at all. And the way in which we find these out is when we obviously do it. We do a client meeting, we do a fact find. We find all about what the client's estate is made up of, hence why we find out that they own a business and what their business is about, how they own the business, is there other directors, do they have a shareholders agreement. We find all this out in the client meetings, and then obviously we can tailor-made the planning to suit that individual, although the couple, the married couple, and make sure that they're getting the most out of their estate planning, and then they're going to leave their estate in the best shape possible, so then when the children inherit, they haven't got all sorts of problems with HMRC
Yeah.
or inheritance tax or anything else, because it's they've left it in the best way they possibly can.
Perfect. So, okay, so that's the importance of lasting powers of attorney and the wills. Now we're sort of getting into a bit of the granularity within the business. So now you've got to start thinking, look, if I die, I've got a value in my business. Yes, I can put the shares into a trust and they can be there, but if there's no financial benefit of those to my family, it's a bit pointless, isn't it? It's
Yes.
they can own shares, but no money ever comes out.
No.
So one of the things that normally happens with this is you would take out a life insurance policy as well. Okay,
Correct.
so tell us a little bit about the purpose of that life insurance policy.
So if we can look at two. There'll be two aspects. We can look at the one-man band who owns a business on his own, and then we can look at maybe a business that has a couple of owners, a couple of directors, maybe they own a business 50-50. But let's just look,
because the one-man band is probably going to not be there, isn't it? It's going to be difficult for it to continue. So it'll basically, the business stops. Whereas if you've got business partners or a bigger business, you'd want that business to continue and
carry on.
Yeah,
exactly. So if we take the one-man band, obviously when that chap's not around, or that girl's not around anymore, what can happen to the business? And what we would always recommend that a one-man band business owner, sole trader would have is key man insurance. So basically, this would be insurance that the business can take out on the business owner, and if then he was to or she was to die, there's money in the business that the spouse can use to get someone in to carry on with the business, run the business as best they can. So it means that if there's a possibility of them selling the business further on down the line, or at least tying up loose ends and making sure that if the business is going to stop, all the suppliers are satisfied, all the jobs are done, you've got this chap in charge just to oversee all that. So key man insurance would be a critical with a sole trader.
Yeah. So it's that sort of, is there enough in there to maintain the running of the business while, if you're not there, if you decided, so my business, it's a consultancy business, I wouldn't bring somebody in to do in effect my job, but it would still need winding up. So there'll be accountants fees and, to actually to do that. But obviously the big thing is replacing my income. Because my business is my income, so that life insurance would then pay off all the mortgages, etc. And we could do a similar thing to what we're saying with the business. It can be paid and then not form part of the estate and lent back again. So it means you've got a chunk of money in which to replace the
so
the asset.
The other spouse can carry on, obviously not the same, because the husband or wife is gone, but they haven't got to worry about replacing that income from their lost partner.
So the next one from that then is where it's a little bit more complicated. Let's say you've got two partners, three business partners. Let's say it's you and I. We've got 50% of this business each. I pop the clogs. So then we've got this issue that my wife then would get my 50% share, because I'd leave it to her through the business trust, so that would be sitting there. But as I said, those shares are no good to her, because I was drawing a salary and a dividend, and maybe the business will suffer a little bit because I'm not there anymore, so it might not be able to be as profitable. My wife might not get on with you. We might be
9 times out of 10.
You may hate her, she may hate you. So the only entitlement she's got is a dividend, and you may decide never to declare a dividend ever again, and just pay yourself a mega salary and the company's just
Well,
never going to make enough profit.
I could start up another business. I could wind it down, start up
Wind it
another
down
one.
and start another one. So, you know, to avoid and give us that security, that life insurance then would be there paid into the company. So tell us what we could do with that chunk of
Yes,
money.
so I find this a lot when I speak to multiple business owners, because obviously the first thing I'll ask is, have they got a shareholders agreement?
Yeah,
I would say probably 40% do, the rest don't. They say they just have a gentleman's agreement, because a lot of the time it's maybe two guys or two girls that are really good friends. They built a business up and no one's really said to them, probably need to get a shareholders agreement in place.
yeah,
So that would be the first thing. So at least that now says where the shares are going to go, where your part of the business is going to go. All right. Now, as we said, we use this example with me and you, Kev. We're in business, we're making widgets. Say the business is worth £1 million. Now, unfortunately, you pop your clogs. Your wife now gets the shares. Now, as you said, we might not get on great. She may know absolutely nothing about making widgets. So it's going to be a bit of a burden on the business. I haven't got your input anymore.
yeah,
You're not there. And also, I haven't got £500,000 to pay her off to
yeah,
get her out of the way. So we're at a very, very sticky wicket, because she's going to be saying, well, I need to get paid for doing basically nothing, or can you pay me off, which I can't do. So what is the remedy for this? So linked to the shareholders agreement, we would have insurance taken out on both of us. So this insurance policy would be, say, the business is worth £1 million, there'd be £500,000 insurance policy on the both of us. And the business would take that out. So in the event of your death, Kevin, the business gets £500,000, right? The your wife gets the £500,000 worth of shares. And then what we would do is we would write a cross option agreement. Okay. And the cross option agreement is very simple. It means that your wife gives the shares back to me, and I give her the £500,000 the insurance. So she's quite happy because she's been paid off. I'm happy now, and I've got complete control of the business. The business can carry on. Everybody's happy. And as I said, nothing has, I haven't got to go and start up a new business, keep paying her off. Everything's been done amicably.
yeah.
So a cross option, so an up-to-date shareholders agreement with a cross option agreement linked to insurance on each of the directors is paramount when you've got a business worth, a lot of money, and you've got multiple owners.
Yeah. And I think we'll come on to the shareholders agreement in a second, but that ability to then be able to make those choices for me is key. Because if you don't have that in place, if you haven't got that life insurance, then it really does put pressure on the other person. And even if we did get on out, my wife and you got on well, financial pressures often can turn that pretty sour.
Oh yeah, because she's lost your wage, Kevin. So she's now thinking, where am I going to be able to get this? I need to get it out of the business. And I'm thinking, well, I'm not getting Kevin's input. I'm having to do twice the amount of work, and I'm paying for someone who's not doing anything.
Exactly. Yeah.
It's not really anybody's fault, but without the right planning in place, it leads to all sorts of problems, and the business might end up folding. And it could have been a really, really profitable, really well-run business, but it's just because you haven't got the right protection in place, it then leads to a situation where you haven't got any choices.
Yeah, and say while she loves me to bits and she will miss me, she'll miss the money more than probably me. So
absolutely.
Anyway, we'll move on, because hopefully she won't listen to this. So that brings us on to the importance of the shareholder agreement, and when you said sort of 40%, my experience is probably less than 10% of people in business that have worked together have a formal shareholders agreement. As you say, most of it's a gentleman's agreement. That we came into this is 50-50. I put in as much effort as you do, and I've seen this when it gets to a point where the two people fall out and it gets horrible. It is toxic. It's nasty. If you don't agree with somebody, then agreeing the value of your business, you're never going to agree.
No.
Ever. So my view with with the shareholders agreement, I always say, look, if you're going to go into partnership, okay, you probably don't need it day one, because you haven't proven the business works. But as soon as the business is, you think, right, we are in this for the long run, then we need to look at really just formulating what the agreement is. And one of the key things I always say to people is go into it as if you hate the other person.
Yes.
If you really
Yeah.
despise the other person, what would you put into that agreement to protect yourself, your family, and to extent the other person? And if you both go into that, and it's a bit like prenups for marriages, isn't it? It's if a lot of these marriages, if they went in with prenups, there wouldn't be the problems that are
No,
happening. I was just
no.
watching the Johnny Depp and Heard trial, which was like amazing sort of bit of showmanship on both parties, and still don't know who was right, who was wrong. But
No, I don't think we ever will, to be
but
honest.
but the only people that ever benefit from those are going to be the solicitors. They rub their hands together when they see uh, sort of two business partners that are disagreeing over things because they just see it's a big paycheck. So once the business is up and running, if you're determined to sort of go at it, then you need to sit down and get your shareholders agreement. So what would you sort of think of the key things that would need to be gone into that particular
Well,
shareholders agreement then?
obviously, we've used the example that a business is owned 50/50. That's not always the case.
Not always the case. Yep.
It's even more paramount where you may have someone who owns more than the other,
Yeah.
or multiple shareholders, because there's obviously more people involved. So that would be my first. That would be my first port of call, definitely. The second bit would be obviously you need someone professional to do it.
Yeah.
We use a local company, and you know them as well. The girl there, Rachel, she's very experienced in reviewing shareholders agreements. So if you've got one in place and it's been around a while, the business has changed, whatever, it's always very good. A little bit like having your will reviewed. It's always good to know what it does and doesn't do, because things might have changed and you might think, well, hang on a minute, might want to add this, add bits in or change some few things around. Someone might have left, whatever. And secondly, what happens to the shares when you die?
Yeah.
Because in some aspects, in some shareholders agreements, the shares go back to the business. Well, in that instance, then what happens to the spouse that's alive? How does that person benefit from the director not being around anymore? And that's sometimes where things can get, as I said already, and I've used this phrase a couple of times, get a bit sticky. And the fact that now the shares have gone back, they've got complete control. What's going to happen now? So having one, yes, paramount with multiple owners. If you've got one, get it reviewed every maybe 4 or 5 years just to make sure it does what you want it to do. Because as I said, businesses change and whatnot, and obviously get a professional to oversee it, because it's an important document, and you want to make sure it's drafted and completed in the right way.
Yeah. And I did just to sort of share a little slide. What I think sort of the key. Some of the key things, and you can put anything into a shareholders agreement. It's it's anything that's relevant to your business. But one of the key things is how you're going to value the business. And if you both parties disagree, then where do you go? Because what you
Yes.
don't want in anything is stalemate. Because again, that just costs loads and loads of money. So if you sort of say, right, this is how it's going to be valued, and we both agree that, don't forget whatever you put in, if you both 100% agree to change it, you can change it.
Yeah.
So
It's there in writing, so at least it stops all this.
It's
He
purely
said, she said.
exactly. It's purely if you hate the other person's guts, then you've got something to come back to. So, you can put in there who's entitled to dividends. Now, a lot of companies have different class of shares, A, B, C's, because that allows more flexibility. So you can bring that in. While I might have only 20% of the business, as an external shareholder, and my business partner's got 80%, we may agree that we have 50% voting rights, because, you know, as a 20%, they could actually vote me out of everything. And
Yes.
part of my reason for investing is I want 50-50, so we can overcome the shareholding in voting. Who can buy the shares? So I might decide to leave the company, and I want to sell my shares to Neil, you know, and Neil goes, you know, or my business partner hates Neil's guts. The last
Yeah,
thing
or it
he
could be
wants is
competition. It could be anyone,
competition.
couldn't I?
So you can protect where the shares go to. You know, again, on death, they would naturally go to your spouse or whoever is in your will. Now, I might not see your will and who you've left your shares to. So, you know, again, we can both restrict where those shares are passed to. And again, we can talk about, you know, you build in the trust and the life insurance as well. So there's many aspects within a shareholders agreement that we need to think about, and that's again why we need to get professionals involved and not just have a scrap of piece of paper and
No.
then wonder why we don't agree when we both pass.
But it's all gone wrong. Yes.
It's all gone wrong. So I think, you know, the key things for this is, you know, it's not just on death. So you've got to think about those lasting powers of attorney, you know, for the health and finance, and then the business as well. So there's three of those. You've got the building of the trust. Now, if you've got other assets, you want to have that in, but also the business trust in there as well.
And how that links to your personal will.
Yeah, how it all links in. You've got the life insurance and key man insurance that might come into this as well. And then you've got your shareholders agreements if you've got other business partners. So we can start to see here, this is quite a complicated thing, and why probably most people put it off and think, oh, you know, I'll get round to it. But the other reason I think people put it off is the fear of the cost. You know, oh, this is going to cost me a lot of money getting professionals in. But it doesn't need to be that. I mean, the cost of not doing it is
far greater.
100 times more than the cost of doing it. To give us a bit of an overview of, you know, what setting up a typical one-man band and a slightly bigger business would so be.
If it was a one-man band sole trader, and he wanted to, he was obviously a business owner, he wanted to get some protection in place linked to his personal will as well. We're looking at probably round about anywhere between, I would say, 2.5 to maybe £2,000 on his own. So that would be belt and braces. That's a will, maybe some trusts on his personal side, a business clause, lasting powers of attorney, and a business power of attorney. All in all, if you've got, if he's married, then basically looking at round about sort of anywhere between 3 to 5 grand, and that means that obviously his wife's or the husband's taken care of afterwards, and the children are looked after, and obviously everything's in order. So when both parents are gone, it just means that the children have got an easier job of making sure, you know, being executors to the estate, to their parents' estate, and making sure that, you know, they haven't got tax implications further on down the line, because, you know, nothing was written in a bog standard will off the shelf. It's not going to have all the clauses that that we provide to make it a lot easier for the children afterwards. When you've got multiple owners, then we're looking at that. But then obviously, if we need to draft up a shareholders agreement, you're probably looking at about £1,200 plus VAT for a new shareholders agreement, and a further funds for the cross option agreement. But obviously that can all come within the business because it's a business expense, and it just means that, yeah, obviously then in your personal and in your business life, it's you're completely covered.
So you know, in the scale of things, you know, between a couple of thousand and maybe 5-10,000, depending on the complexity, you know, compared to what you would save within tax, inheritance tax, in solicitors' fees and arguments down the line, it really should be seen as a no-brainer, and you get the VAT back and you get tax relief on it because it's all part of your business estate. And
Well, yeah, and if it's something you've put your heart and guts into, being a business owner, and something to be proud of, why would you want it to go to rack and ruin, all because of not getting some planning and crossing your T's and dotting your I's, and making sure you're leaving a legacy for your spouse and your children in the future.
Yeah. And the big thing is, look, none of us are indestructible. Shit happens. We know that within business. This is that insurance protection. God forbid, let's hope it never happens. And the
well,
five grand was a complete waste of money. But you'll if it did happen, then it will be the best decision you've ever made.
Oh no, 100%. It should really be like having house insurance and car insurance, having your business protected, because you do that just in case. You're doing a lot of this just in case.
Yeah.
Because as you said, you don't want to be leaving a mess for your loved ones.
And in a way, it's more important because okay, you lose your car. What's the ramifications? The ramifications of you dying and your business is your income stream, and is massive. So we really need to be thinking about this and making sure our families are looked after long after we're gone. So the only thing, don't take too much life insurance out, otherwise you're worth more dead than you are alive, and then you just got to watch your back all the time. But,
well, that's right, yeah.
So look, it's been great having you on, Neil. So where can people contact you, Neil, if they need more information?
Well, I'm on LinkedIn, I'm on Facebook, but they can contact me. My telephone number's 077 152 7752. I'll be happy to take a call if anyone wants any advice. My email address is neil@ccs, then a hyphen uk.co.uk. And how I would normally how I normally conduct myself is that if someone wants to have a chat, we normally have a meeting, and it's normally a fact find. I find out as much as I can about the client and what they want to happen and basically what they've got, and then obviously from that we can start talking about formulating recommendations and what that looks like.
So initial talk about what needed would be a free consultation, and then you can decide.
All free consultation, yes. No, and it can be done either over Zoom or face to face, depending on location and depending on what the client wants to do.
Yeah,
and that's what it would look like, an initial first chat.
Yeah, and shareholders agreements. If anybody wants to talk through those, I'm happy to have that initial sort of advice, and then we've got people who will then do the legal side of things. Because I always find if you go to legal people exactly what you want, then you'll save half your money. What happens in shareholders agreements is to and fro, and time it takes. Whereas I've done enough of them in the past to know what should be in there from a business point of view. So more than happy to help with that as well. So thanks for listening, watching, guys, and hopefully we'll see you on another one of these informative chats. So thanks very much, Neil. Enjoy the rest of your day.
No, thanks, Kevin. Thanks, guys. See you later.